go through a whole closing and you're waiting for the till to come over, the revised till. So now in this truth in lending disclosure statement, this is a case from a while back that when I was reviewing my client's loan docs, something stood out that was very, very unusual. The APR, they have it at 1%. That's a pretty good rate. This was one of those option arm loans. Remember those from Washington Mutual? Everybody was doing those a few years back. Those were just ridiculous loans. It would start off, let's say, like at 1% until your first payment was due. So just on the interest before your first payment, yeah, the interest was 1%. Then at your first payment, it would be the index, the LIBOR index usually, plus like the 6% or something. So it would skyrocket. But your payment was for the first year was based on it still being 1%. So you'd have a negative amortization. So at the end of the first year, you ended up owing way more than you started with. And then the second year would reset, it would readjust to a much higher rate, and your payment would skyrocket. It was just a ridiculous loan, and I would ask clients, you know, when they were getting those loans, I go, why would you get a loan like that? It just sounds ridiculous. And typically the answer was, well, this is the only loan I qualify for. And my loan guy said I can refinance next year anyways, and everything's going to be great. Like, I just don't get it. But so you see the APR, it says 1%. Well, the APR is supposed to be a disclosure as to what your true cost of financing is over the term of the loan. I mean, there's nothing 1% about this loan except for the 18 days before you had to pay your first payment, or actually, no, like a month and 18 days before you got to make your first payment. So this is a serious truth in lending violation. It's a pretty serious discrepancy over what the true cost of his financing is. They have his amount financed at about $1.5 million, and his total payments over the term of 30 years to be only 1.736. That's almost like, that's like interest free. I mean, it would be impossible. Even if rates stayed at the absolute minimum, he would be paying millions of dollars over the term of the loan. So, so this is one where we stopped the bank right away, and basically he's been in his house now in like a year and a half. The bank hasn't even filed anything since we raised this issue, and it's just a matter of trying to work out a loan modification. But they did offer one modification, but he's a builder. Right now he's just not building anything. So we're hoping things will turn around for him, and they will offer another modification that he will be able to work with. And but they're in no hurry to take his house away from him. There's another one after that, which is an assignment of a mortgage. Now, this one is this assignment was executed in the spring of 2010, recorded it in May of 2010, transferring it to this lender, the Bank of New York, as trustee. And they're the party that filed the foreclosure case. Only problem is they filed the foreclosure case way before this was ever done. So there was another bank involved, but the foreclosure was filed by someone else, and so we raised this as a standing issue, and the bank is now indicating that they are willing to work with us and get the provide the modification that our client is hoping for. I got another one here. This is an affidavit of prove-up. Now, this is something that the bank submitted by an officer of EMC Mortgage, stating under oath that they are familiar with the allegations, that everything is truthful and accurate and all that. And the court relies on this document to basically grant grant the bank their foreclosure judgment. So it's a very important document. Now, problem is, if you look at the next page with all the signatures, the same person who is saying that they are the vice president of EMC Mortgage and saying that they have personal knowledge of the facts contained here also is the vice president of JP Morgan Chase, Deutsche Bank, Bank of America, US Bank. I mean, she has quite an extensive resume. She's very, very popular with the banks. She must be, either she gets around and moves from job to job, or she's a multitasker. I don't know. But when we raised this with the bank's attorney, they withdrew their motion for summary judgment. So now I'm not saying that this person's one of those robo-signers. I don't know. Maybe we'll give her the benefit of the doubt that she really does know all the information that she says she does. But I'd love to depose her. I'd love to. Would that be great? But I don't think we'll get the chance, because I have a feeling my client is going to get the modification that he's looking for. So those are examples of what you can do for your client to get them what they're looking for and provide a valuable service.